Honorable Court of Appeals of Tennessee is in session. Please be seated.
Good afternoon and welcome to the Court of Appeals. Take just a moment before we get started, make sure everybody's on the same page. I know we've got experienced practitioners here, but I always feel better just touching on the ground rules, so to speak. An oral argument, each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, please request that from the court after you've come up to the podium to begin your argument, but before you start it and after you've introduced yourself. You may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. The lighting system on the podium is what I believe to be very straightforward. Once you begin your argument, the light will turn green. Once you're about to run out of time, the light will turn yellow. And when your time has expired, it will turn red. We ask that you respect those time constraints. Also, one thing I want to be sure and remind everyone is all these arguments are being live streamed. So be very careful about what you say, because once you say it, it's out there in around the world, I suppose. So they are being live streamed. Your panel this afternoon will consist of Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the first case, please.
Jessica Neal versus Patton and Taylor Enterprises, LLC.
All right, we will hear from the appellant.
Good afternoon, Your Honors. My name is Daniel Seward. I represent the appellant in this cause, and I would respectfully request 5 minutes for rebuttal.
All right, sir. You may proceed.
Thank you, Your Honor. This appeal involves a release that was entered into by Jessica Neal involving a auto accident or an accident involving construction materials in Memphis, Tennessee, back in 2015. And the reason we're here today, Your Honor, is that Ms. Neal executed a release with the driver of the vehicle she was an occupant in shortly after the accident, within 30, 45 days after the accident, who insured the driver, Daniel Bull, who was insured by Geico Insurance Company. The release that Geico presented to Ms. Neal to sign contained language which the appellee and the trial court felt released any and all tortfeasors from any potential claims in this cause. The appellate respectfully takes issue with that, and first states that the release it is specific because it contains the language of and from is very important in this case because it defines the specific entities who are being released and also any subset of those entities which fall under the umbrella of the release. So therefore, our position is it is straightforward and clear. It specifically releases a certain individual, Geico, Daniel Bull, then any and all individuals which fall under the umbrella of that release. And the language of the release, although blurry, we attempted to present a clear copy, but I believe in my brief on page 9, I cited the relevant language, Jessica Abdul Jaber, also known as Jessica Neal, for myself, my heirs, executors, administrators, successors, and assigns hereby remise, release, and forever discharge Daniel Sherry Bull and Geico Advantage Insurance Company, releasee, successors, and assigns, and or his or her, their associates, heirs, executors, and administrators, and all other persons, firms, or corporations, but here's the magic language, of and from any and every claim. So what the trial court did, in my humble opinion, was basically extended the holding in the Petros versus Shelby County case and basically said this is a general release which is to be interpreted against any and all tortfeasors. It therefore released in this case, Patton and Taylor Construction Company, who had basically parked or placed construction materials next to a hotel being built in downtown Memphis, which was upon the city streets, and that was the materials that Miss Boyle crashed into in her car, in which Miss Neal was a passenger. So having said that, our position today is the release is specific. It only releases the named individuals or the entities that fall under that umbrella. Patton and Taylor is an LLC. They're not named in this release. They were not an intended beneficiary of the release. A claim was not contemplated against Patton and Taylor on the date the release was entered into. And I look at the plain language, even though the release was drafted by Geico Insurance Company, any all interpretations or inferences should be construed against them. And in this case, Patton and Taylor is attempting to ride on the coattails of Geico, so therefore any interpretation of the policy language should also be interpreted against Patton and Taylor as to coverage of the release. And I noted in my brief, Webster's dictionary defines the word of, and it's used to indicate a derivation, origin, or source, and that could be any subset of Geico Insurance Company of Boyle, or used to indicate, specific identity of a particular item with a category. And why is it important? Because it's very specific. It does identify the subset which Ms. Neal released that day. She released Daniel Boyle. She released Geico Insurance Company. She released any entity, individual, employee, servant working under that umbrella of Geico Insurance Company, but she did not release Patton and Taylor. And so therefore we argue that the release is inapplicable to the claims of Ms. Neal in this case. Defendant has cited no precedential case value in Tennessee, which basically said this language includes Patton and Taylor. They referred to numerous other decisions from other jurisdictions, but nothing from Tennessee. So I would submit to the court in the case that we.
Do you have any Tennessee cases that support your interpretation of this specific clause?
I basically just rely upon plain contract interpretation in Tennessee. I don't think there's a case on point of precedential value that says of and from means something else. I don't have a case that says that either. But I'm arguing that the literal interpretation of the language makes it exclusively applicable to Daniel Boyle and the Geico Insurance Company and any subset which falls under it. So therefore, I would submit that the...
what about the language after administrators where it says, and all other persons, firms, or corporations?
And that's why I included the language of, because you have to... Of and from was placed in this document for a reason. The lawyers at Geico didn't put of and from in the document by chance. Of and from refers back to the subset, the literal interpretation of a derivation or source of origin of. That's what Daniel Boyle, Geico, and any of those listed entities are parts of the subset.
Well, when it says all other persons, firms, or corporations, how's that limited?
I think the word of, respectfully, my interpretation, Your Honor, of limits the language to that subset. It doesn't say, like in the Petros case, any and all claims of any defendant known and unknown, or whatever the language says, which is pretty wide open.
Well, this is pretty wide open language.
Well, Your Honor, but my position today is it did not, respectfully, it did not include Patton and Taylor. The claim against Patton and Taylor there had been no formal demand or claim made against Patton and Taylor on the day this release was entered into. It was not contemplated. It was outside the scope of the release. And respectfully, I would say, I would submit that the release does not include Patton and Taylor.
What, does some type of demand or have to be made before the release can be effective?
My review of the case law, it says that the claim is contemplated. I'm not sure what contemplated means. I would think it means that the plaintiff knew about it or had a reasonable opportunity to know about the claim and either made or didn't make the claim.
Does it have to be contemplated by the plaintiff or contemplated by the defendant? I
can't answer that. I would say my interpretation, it would be contemplated by the plaintiff because it would fall under the scope of the release of what they're releasing and who they're releasing. So if the plaintiff didn't contemplate it, it would be beyond the scope of the release they enter into.
Does the record reveal whether the plaintiff had counsel at the time the release was executed?
The plaintiff had counsel, and it was myself, Your Honor.
Okay.
I would basically rely upon the language that I've used in my brief. I do want to touch on one other point in the last minute and a half that I have. I would respectfully again state that the language, to interpret this language as being enforceable against Patton and Taylor, or against Ms. Neal and her claims against Patton and Taylor, would expand the scope of contract interpretation and releases in the state of Tennessee. It would thwart or the source of, the purpose of settlements is to resolve matters. I think this would open up, I would just say, a lot of issues involving whether parties should enter into a release with Geico or not. This is a standard Geico release. I'm not aware of any other cases ever become before any Tennessee Court of Appeals or the Supreme Court, which the court said this language is enforceable against any and all entities in the world, known or unknown. So I think it's beyond the scope. They're asking you to expand the scope of the release, and I believe Tennessee law is clear that it has to be specific where the terms are specific. And I did the second issue. The Honorable Trial Court Judge Russell did not rule on the second part of the motion of the appellee, but basically they presented the affidavit of the driver who said the accident's all my fault. The appellate presented a sworn affidavit of Jessica Neal, who said she was driving reasonably at the time. It was dark, and the construction materials were in the road when they hit the materials. So I think that would present a material issue of fact on that second issue. And I'll respectfully have a seat. Thank you, Your Honor.
Thank you. We will hear from the appellee.
Good afternoon, Your Honors. I'm Michael Derrick of the Shelby County Bar with the Shuttleworth firm down there. I represent the appellee Patton and Taylor Enterprises. By way of context, Your Honors, this underlying accident occurred when two ladies at roughly 5 a.m. going north on what used to be called South 3rd, just before Madison. According to, in the record, Boyle lost control of her vehicle, swerved to the right, ran through a fence that was surrounding a construction site. The construction was the conversion of the old Winchester Press-Cimeter building into what is now the Hotel Napoleon, and hit one of those construction dumpsters that we all see that are used in conjunction with the demolition and construction of those types of projects. She soon thereafter reached a settlement with Geico Insurance, the insurance carrier for Boyle. And I won't belabor the language in the release. It was presented to you all in the briefs. It's in the record about 4 times, and Mr. Seward just went through it. What I will say about the release, it is a general release. There's no question about that. It is a general release by its clear language. The clear language that the appellant seeks to use to make the release sound confusing not only is contrary to the law and the interpretation given to this exact release language by multiple other courts in other jurisdictions, and those have been cited, or a sampling of those have been cited in our brief, but it also defies the standard usage of common English language. If we simply diagram that sentence, we can see where the subject is, where the verb is, or where the verbs are. We see the object, and then we see the prepositions of and from. And we know that the object of the preposition follows the preposition. We learned that in the 8th grade when we had to go to the blackboard and diagram sentences. To To twist this language in any other way not only renders what is otherwise clear on its face to be confusing, but it also defies the common usage of English language. It would, in one court that we cited below, it would turn the English language on its head to change this verbiage in the manner that the appellant proposes. Now,
Would you say this is a contract? Is that what?
this is a contract. This is a contract.
Should that be interpreted based on what the intention of the parties is?
Your Honor, the contract is interpreted based upon the intention of the parties, plural, as represented by the clear language used in the contract. So if the language is clear, as it is here, then this language evinces us of the intent of the parties.
What would be the intent of either of these parties to release you?
Well, there were a couple of reasons, and that's a very good question. In this case, and the record makes reference to it, but it doesn't go, it's not relevant for today's appeal. But there was actually, Ms. Boyle was a defendant in this lawsuit at one time. She was sued by Patton and Taylor. She was sued separately, and then Judge Russell consolidated both cases, because when she ran that car into this construction site, she actually damaged our property. We had a property damage claim against her. So she's seeking to eliminate any claims that might come back against her, because if we're out of this, now we don't have contribution or indemnity anymore, but if we're out of this case, then it certainly lessens her exposure to other parties who may come along. And in this case, I think it was clear to the parties that the at-fault or alleged at-fault party was settling this lawsuit. The question was asked of Mr. Seward a moment ago as to the contemplation at the time of the execution of the release. Who has to hold that contemplation or be in contemplation?
How does that protect, what you just described, how does that protect her? How does this language protect her? She's releasing everybody else. How does that protect her from a lawsuit that you have against her?
Well, it doesn't directly protect her, but it certainly lessens the impact that if we are involved in litigation, that we might join her in that litigation. And we had a basis to do that because of the property damage we suffered. Prior to McIntyre, obviously, we could have looked at third-party claims under contribution and indemnity, and we pointed the finger at her. But we did file a separate suit. That's not the issue before the court today, but I think it gives context as to exposure that she could have ongoing indirectly related to this accident. Now, to get back to the question that was asked of the appellant as to who would contemplate that, and the answer is the parties, not just one or the other. As we know, the subjective belief or interpretation by one party is not sufficient to set aside the clear language used in the contract. In this case, there's not any question that the language is clear. We looked at that. But there's also in the record the statement of Boyle. It's on page 65 of the record, where she says, "We secured a release of all persons and corporations," and I'm paraphrasing, but the language used in this release. She does not come forward and create some question of fact or issue as to whether this release contemplated exactly what it said. And there's nothing in this record that says otherwise. There's no claim of overreaching, no claim of misrepresentation of the scope of the release, or any sort of untoward activity in connection with the execution of this release. The claim was known to the plaintiff at the moment they ran through this fence and hit the dumpster. She wasn't comatose. She didn't wake up later and think, what happened to me? She knew she had been hurt in a car wreck, and she knew what they hit. That was the contemplation. She knew she had her claim. It's not like a claim that's subsequent to this event, and even subsequent to her executing the release, her case got worse because she was malpracticed upon, for instance, by one of her treating doctors, and I use that as a hypothetical, or some other cause of action that had accrued that may have been related to this. That's not in this case. Her claims were known to her and contemplated on the day she signed a release that clearly on its face is unambiguous and using the rules of construction and English language says what it says, and it says what the appellee contends it says and what the trial court found that it says, and consistent with the Petros case and the other cases that were cited in our brief, both within the state of Tennessee and in surrounding states. As to the second issue raised by the appellant, I don't think that's an issue. It wasn't dealt with by the trial court, so we didn't take time to deal with it. If that issue had been resolved by the trial court, then I think it would be proper to be here. It was not addressed. The court specifically said that issue's moot. This case is over. The release says what it says, and we don't need to kill any more trees to go on to another issue. And I'm paraphrasing there, but that's in sum and substance what came out of the trial court. So that issue's not even properly before this court. Any questions from your honors?
See none.
Thank you so much.
Thank you. I believe you have 5 minutes.
Yes, sir, thank you.
I want to make sure I, go ahead, get the issue defined here. You're not asserting any defenses to this contract. You're simply asking this court to interpret the contract. Is that correct?
I'm not alleging fraud or any improper act by.
Duress or anything like that? You're just
Sir,
asking, you're not asserting fraud, duress, or anything like
No.
that? You're simply saying, we got this contract, what
Yes,
does
sir.
it mean?
I'm saying that the plain language of the contract is clear that it applies only to the subset of the individuals. Of and from is in there for a reason. It's not in the Petros case. It's in this clause, though, and it was drafted by Geico for a reason. Those words are in there. And of refers to the source. The source is Daniel Boyle and Geico and any subset of those individuals who fall under that umbrella.
You're saying that Patton and Taylor is not a party to this contract?
They were not contemplated, or they're not included within the scope of the release.
They're not a third-party beneficiary?
No, sir.
They're not entitled to any benefit of this contract?
Yes, sir, that's what I'm.
Is that what you're saying?
Yes, sir. I would just, well, my time is very limited, and I had a wreck this morning, so maybe I was a little disheveled when I first walked in, but I would tell you, I think it needs to be stated today, this accident happened around 5 in the morning. The materials were not in a private parking lot that were owned by Patton and Taylor. They were parked on a city street in the city of Memphis. There was a dumpster. There was a fencing around the dumpster and construction materials placed in a city street in which we allege there was improper lighting and notice of the materials being there. That was the source of our allegation of negligence against the defendant in this case. And so Miss Neal issued a sworn affidavit which basically said she was sober, alert, and a passenger in the car at the time of the accident. It was so dark she couldn't see the materials until they actually hit the materials. Daniel Boyle was brought in this case from a different lawsuit that Patton and Taylor filed seeking property damage against Daniel Boyle. To my knowledge, Daniel Boyle never even came to Memphis, Tennessee. She issued an affidavit in Florida which basically got her out of this lawsuit or any claim against her. So what her motivation was to enter this release, that's for another day. But I would state that, that the release she issued has no merit to it. Ms. Neal has issued a release which refutes it and provides a material issue of disputed material fact in this case. There was no consideration paid by Patton and Taylor. They were not contemplated to be a beneficiary of this settlement. And our position is if the language was ambiguous, if it's open to two interpretations, Ms. Neal still gets the benefit of that interpretation. And if one says, well, of refers just to the entities that I referred to, or if Mr. Derrick has stated it might refer to anybody and everybody, well, that's two different interpretations. So if that's the case, at this stage of the proceeding, Ms. Neal is entitled to the benefit of the doubt of the inference. So I would respectfully state that they're asking this court to expand the scope of the Petros versus Shelby County ruling, which I believe Judge Stafford authored. And I believe the terms of the release go beyond the scope of releasing Patton and Taylor in this case. And I will submit it. Thank you, Your Honors.
Thank you.
Unless there's questions.
I believe.
Thank you.
I see none. Thank you.
Thank you.
Thank you, gentlemen. We will take this matter under advisement and endeavor to get you an opinion at the earliest possible